Joanna Peck, licensing agreements are a big deal to a lot of co-op and condo boards these days with Local Law 11, construction, and so forth. Mm-hmm. You're a litigator.
Yes.
And you've got strong feelings about what co-op and condo boards need to do when they get ready to start negotiating these licensing agreements. What is your advice?
I think, first of all, the general counsel generally is fine with 90% of the transactional work that a condo does or a co-op does. But with respect to these licensing agreements, because of the technical considerations that are involved and the fact that they may go south, whether or not you're looking to get the license from your neighbor, you're doing the construction, or you're negotiating with the developer, it's important to bring that litigator in at the beginning so that they can set up the platform in the event, unfortunate event, that it goes sideways and it has to be litigated.
Now, does the litigator help negotiate the licensing agreement, the fees, the insurance, the protections for the building and so forth? Or?
Yes, they can work definitely in conjunction with the general counsel, but I would strongly advise that the litigator is involved in that piece because having the nuances of in particular, the technical considerations is important if it ends up in court.
Now, you don't want to go to court. No co-op or condo wants to go to court.
No.
That's the goal is to stay out of court.
The goal is to avoid court.
But there are certain situations where the two parties just cannot come together.
Sometimes it's unavoidable. Sometimes some of the negotiating terms just cannot be agreed to and people dig their heels in, as the case may be in New York. And having that litigator there at the beginning can help the condo or co-op set up the right team of people so that the unit owners or shareholders are best positioned when they do go into court in that event.
Okay. Now, the licensing agreement has a couple of big working parts. There's the physical stuff. You help negotiate that. You have architects involved?
Yes. The way I look at licensing agreements is I really carve them into two components.
Okay.
The first is your technical components. Those are the items about what, for example, if somebody is developing next to you and you're negotiating with the developer, what impact is that construction going to have on your building? Physically. And what protections, life and safety protections, need to be implemented?
Okay.
What protections need to protect the building itself from physical damage? And what impact is that construction going to have on the unit owners in the building?
And what's the second aspect?
The second aspect are the economic considerations. So things such as insurance requirements,
sure.
Interference of use and enjoyment, and you may also want to have, because you may have specific unit owners or shareholders that, let's say, have a terrace or what have you, that are going to be more impacted by others, there may be special economic considerations that the attorneys need to negotiate on behalf of those individuals.
So once you've got the agreement in place and you can't come to terms with the neighbor, mm-hmm. then the litigator is, if the litigator was involved from the get-go, you're ready to go to court. Is that the goal?
It's not the goal to go to court,
no,
but it is the goal to have the litigator involved, because that person's going to have the best speaking position. They'll have the details and nuances of all the facts, in particular the technical considerations. That's number one. Number two, they will also have put together the team of engineers and architects that may be involved, everybody from the structural engineers to geotechnical engineers, if that's the case, who will be working with that attorney, that litigator, to help advocate for their client, to get either the right protections in place and to argue that before the judge, or in the case of the condo or co-op, doing the development themselves to explain why what the building is proposing to do is sufficient and compliant with code.
As boards embark on negotiating these agreements,
yep.
They have a general counsel, but your advice is what?
My advice is that the general counsel, and working in conjunction with the board, gets a litigation attorney involved to work either in conjunction or in tandem with that general counsel, or to take the lead. There's another subtle aspect here of but it may not be so subtle in these negotiations, is that if you get a litigator involved at the beginning and not just a general counsel, that the other side with whom you're negotiating with will know whether or not you really know what you're doing. Because the litigators are the ones that have vetted the issues before the judges. They've educated the judges. It's frankly a fairly newer area for some judges who don't know all the details regarding these license agreements. And so that will also help serve as that platform for the board.
Right. So the neighbor negotiating the agreement will take it more seriously if there's a litigator involved from the get-go.
I certainly would. The moment I'm in it, when I'm working with a client representing a condo, and I see the attorney that they have on the other side, I know immediately whether or not they really know what they're doing.
Okay. Well, thank you, Joanna Peck.
Thank you.